Today I'm here to discuss about the case Devadassan versus the second class executive magistrate Ramanathapuram and others, which came before the Honorable Supreme Court of India. Here, the basic facts of the case has been already discussed. Again, here the appellant was indulging in criminal activities, and the respondent number one of this case, who is this executive magistrate, after issuing a notice and giving opportunity under uh, section 117 and section 1110 E of CRPC, passed that order. And according to that order, the appellant of this case has executed a bond to maintain good behavior and peace for a period of 1 year, and bond of rupees 50,000 as penalty to the government in case of breach or else face the proceeding under section 122 clause 1 of CRPC. Here section 117 of CRPC deals with the order to give security. It states that if upon inquiry, if it is proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, the person in respect of whom the inquiry is made should execute a bond with or without sureties, which the magistrate shall make an order accordingly. Section 110 clause E of CRPC states that a person who habitually commits or attempt to commit or abets the commission of an offence involving the breach of peace. So the penalty has been imposed, and a bond was executed. After the execution of the bond, the appellant was found guilty for an offence of commission of murder under section 147, 148, 342, 302, read with section 109 and 120 clause B of IPC, which all deals with rioting with armed weapons, punishment for wrongful confinement, murder, punishment for abetment of an act committed where express provision was not made for its punishment. The respondent number one, that is the executive magistrate, by an order found him guilty for the breach of the bond, ordered his arrest and sent him to the custody. The said order of the executive magistrate has been affirmed by the High Court of Judicature of Madras, Madurai bench. Here the appellant has challenged the order of the High Court as well as the first respondent. The learned counsel for the appellant has submitted before the apex court that the imposition of conditions in the bond by the executive magistrate without due inquiry and without affording reasonable opportunity cannot be justified, and the appellant cannot be held guilty in such conditions and cannot be sent to the custody without hearing his part. For this submission, the counsel for the appellant pointed out certain case laws. First one is Aldanish versus State of NCT of Delhi, 2018 judgment of the Delhi High Court, which issued guidelines to impart training to the officers who pass orders as administrative authorities. Then second judgment is Devi versus Executive Magistrate, which is the judgment of Madras High Court in 2020. Similarly, they also pointed out Premchand versus Union of India, which is an important case which was passed where the judgment came in 1981, which emphasized that the police officers who acts upon their power cannot cannot act in a manner that the personal liberty of others cannot will be affected. And similarly, another case which was pointed out was Gopalan Achari versus State of Kerala, 1980 judgment by the Supreme Court, which emphasized the importance of Article 21 of the Constitution of India. The counsel for defense submitted that already eight criminal cases were pending against the appellant, and because of that, the bond for good behavior was taken in exercise of the power under section 1117 of CRPC by the executive magistrate asking for a security. And the said appellant has already violated the bond which led to the order under section 122 clause 1B of CRPC. Here, the counsel for defense submitted that the appellant breached the security by involving in a murder case, and the executive magistrate has given a show cause notice for fixing for appearance. As per the reply given by the appellant has not raised any issue regarding the executed bond and does not even deny his involvement in the murder case. So the competent authority has made the order by following the procedure. Uh, when it comes to the decision of the Supreme Court in this case, after going through the facts of the case and this, considering the submissions of the both parties, the court pointed out that already the 8 criminal cases were registered against the appellant in between the time period of 2012 and to 2021 for offences including simple and grievous theft and offences under Arms Act. And it was also pointed out that the respondent number one, that is the executive magistrate, had conducted an inquiry based on the report of the respondent number two, and a show cause notice was already issued. And respondent number one has, after satisfying all these things, after conducting inquiry and after getting the satisfaction, the appellant was causing breach of peace in the locality. So he was asked to furnish a bond of rupees 50,000 as surety for a period of 1 year under Section 117 CRPC, failing which he may be imprisoned under Section 122A Clause A of CRPC, or in case of breach of condition, recourse under Section 122 Clause 1 Clause B of CRPC may be taken. Here, the court held that Chapter 8 of CRPC confers powers to the executive magistrate to take bond for maintaining security and for keeping the peace and good behavior by the citizens. And the court pointed out certain sections of CRPC, that is Section 107 of CRPC, which deals that on receiving information that any person is likely to commit a breach of peace or disturb the tranquility or to act in any wrongful act way, the executive magistrate may have the power to show cause on violation of the terms of the bond so executed for maintaining the peace. Under Section 108 CRPC, similar power has been given to the executive magistrate for maintaining this, getting a bond for the security for good behavior for persons disseminating seditious matters. Section 109 and 110 also gives the power to take security for good behavior for suspected persons and habitual offenders. Here in this case, the court have pointed that the order was passed by the executive magistrate was under section 1111 and 1117 of CRPC for security on violation. And here the counsel for the appellant has not brought on record that how and in what manner the procedure contemplated under different section of chapter 8 CRPC has not been followed by the executive magistrate. Here the order has been passed by the executive magistrate after the violation of the bond executed by the appellant. So the order of our respondent one was passed after following the procedure under the law by issuing show cause notice and hearing the party after giving him a reasonable opportunity. And the High Court of Judicature has also affirmed the similar manner. So the order passed by the respondent one and the confirmation ordered by the High Court does not need any interference from the Apex Court, and the case was dismissed because no procedure has been violated by the above authorities.
Uh, which is Devadassan versus number 1, second class executive magistrate Ramanathapuram. Number 2, Inspector of Police, Uchipuli Police Station. Number 3, Superintendent of Prison, Madurai Central Prison. So these are the 3 respondents in this, which is criminal appeal number 388 of 2022. 1 SSCR 868. That is the reference number. It was rendered by a division bench of the Supreme Court, that is Indira Banerjee and Justice J.K. Maheshwari, and Justice J.K. Maheshwari delivered the judgment. The facts of the case has been well explained by almost all the speakers, especially the sections as well as the all other aspects with regard to the verdict also has been rightly mentioned by Nivya. And now my role here is just limited to giving a brief aspect of what is the facts of the case and some 3 extra points which I would like to mention. That's all. So the facts of the case is a person herein, Devadassan. He is a habitual offender. He has 8 criminal cases pending against him. A report from the police was forwarded to the second class executive magistrate, who is the Tahsildar of that particular area, and he held an inquiry. And on furtherance of that inquiry, the person was asked to submit a bond uh, for about 50,000 rupees. And in case of the breach of that particular bond, he would have had to uh, undergo proceedings under section 121(1)(b) of CRPC. But what happened was he was again he got involved in a criminal case registered in Uchipuli police station, which also had a murder charge in it. And so, in pursuance of section 121, 122(1)(b), his he was arrested into and placed in prison. So this is the brief facts of the case. Now, various questions were adduced from the part of the appellant regarding the administrative laxity. That is a normal, what you can say, normal allegation raised, a peculiar allegation raised against administration of not following the orders, and baseless allegations were also leveled against them, citing some normally surface case laws regarding, for example, Gopalan Achari versus State of Kerala, which is emphasizing the importance of Article 21, that is especially right to personal liberty, which was also rendered in this judgment that court can reasonably enter into the personal liberty space if there is enough, if it follows the procedure established by law. Even right to life is under peril if it follows, if the system follows the procedure established by law. So that's all. That was the judgment in this particular case. Now, respondent's version was very well. There was reasonable opportunity was adduced to the appellant herein, and he made his submission. He did not deny a case having been registered. The only thing he said was he was not found guilty in that particular case, but he was accused in that particular case, and later he got involved, and which means he gets involved in a criminal case, and similarly he was held guilty of breach of conditions, and he was taken into custody. So this is particular case in which High Court has not intervened, then 136 entry of Supreme Court is not warranted. Uh, that was the contention of the respondent side from Dr. Joseph Aristotle. Now, various aspects have been dealt with, and almost all the sections of CRPC dealing with this has been well explained by almost all the members. And now I would like to invite your attention to one of the important cases which I came across, which is a Directorate of Enforcement versus Deepak Mahajan and another, which was rendered in January 31st of 1994, in which in paragraph 61, it states that Chapter 8 deals with security for keeping the peace on conviction, on information, and with peace and with security for good behavior, covering from section 106 to 124 of the code. The provisions of this chapter are preventive in their scope and object. They are not intended to punish, but to prevent against forcible harm to as commission of crimes. Of making any investigation by any police officer as contemplated under clause 2 of the code to a magistrate pertaining to security proceedings under this chapter, though such proceedings are criminal in nature but not relating to any offense. Again, it is mentioned in that case that magistrate under section 122 of code can commit any person to prison if that person ordered to give security under section 106 or 117 of code does not give such security. Similarly, in section 151 under chapter 11, that is preventive action of police, the police officer is empowered to arrest a person so as to prevent the commission of a cognizable offense, where commission of offense cannot be otherwise prevented. So subsection 2 of section 151 restricts period of detention of person arrested in custody for a period exceeding 24 years unless his further detention is required or authorized under any of the provisions of the code or for any other law for the time being enforced. Now, an Administrative Reforms Commission report is to be cited in this behalf, which is second Administrative Reform report relating to public order. In its fifth report, which relates to public order, It was observed in paragraph 6.1.3.1 that under security proceedings, that chapter 8 of CRPC confers upon executive magistrates wide powers to enforce preventive measures for prevention of future commission of offences against public order. And in paragraph 6.1.3.2, it was observed that even though wide powers are available to authorities, timely, well-planned and judicious use of these provisions by local police and magistracy is often lacking. The field functionaries, both in executive magistracy and police, are often not fully aware of the manner in which the provisions should be used. In many details been described for these purposes. So these proceedings, once initiated, then the will conclude and are allowed to lapse after presentation was put in that report, which is mentioned in paragraph 6.1.3.1 needs to be emphasized. Training and operational manuals for police and executive magistrates need to be revised on these lines. B. Regular supervision and review of these functionaries by district magistrate and the superintendent of police respectively should be done to uh, to give attention on effective use of these provisions. For this purpose, a joint review on a periodic basis by district magistrate and superintendent of police should be done. The recommendations were accepted by the group of ministers, and an advisory was issued to all states or union territories on 24th 2007 to take necessary action. So these were things that, and lastly, I would like to give the report titled "A Breach of Bond with Securities," which is titled in April 1984. An anomaly was found in defaulters where we are breached upon. Hence, it was recommended to include with securities in place of without securities, the wordings without securities in place of without securities, and it was so. This is some of the things which I could find. Uh, Other than that, almost all of the points have been rightly mentioned by almost all the speakers. That's it.